But counsel to the EFCC, Adebayo Adelodun, SAN, submitted that El-Rufai and the other accused persons were newly brought before the court on the basis of an 8 amended charges and urged the court to allow their immediate arraignment. He pointed out that, as a matter of law and fact, the objection on this ground has become mute, spent and academic by reason that the prosecution had filed an amended charge. He vehemently opposed the plank upon which the defense counsel based their objection to the arraignment, saying that the objection was doomed since it was based on an unreported decision of a court of appeal that had been voided by the Supreme Court. The court, however, granted EFCC leave to prosecute the former minister and 2 others on the amended 8-count charge. This, the court said, was in accordance with Section 208 subsection 1 of the Criminal Procedure Code and the EFCC Establishment Act. When the case came up on April 7, the accused took their plea as Akin Olujimi SAN, counsel to the first and second accused persons, applied for bail on behalf of his clients, saying he had earlier filed an application to that effect earlier in the day, which had been served on the prosecution counsel. He placed his request for bail on the fact that it had been granted to them by EFCC and also by Justice Adamu Bello when the accused were initially arraigned before a federal high court. He also stressed that the duo had completely complied with the conditions of the administrative bail given to them by the EFCC. Similarly, counsel to the third accused person, Effort Okon, who stood in for Chief Kanu Agabi SAN, moved for bail for his client, citing the same conditions raised by Chief Olujimi. Justice Umar, while ruling on the applications, said it was pertinent to note that granting of bail is at the discretion of the courts. He also said he was aware the accused persons had been granted administrative bail by EFCC and that the charges against them were bailable. He thereafter granted bail to the first accused person, Nasser El-Rufai, on self-recognition, while the second and third accused, Altine Jibrin and Ismail Iro, are to enter a bond for the sum of 50 million naira only each, with a caveat that if they default in appearing for trial, they would forfeit the bail bond. The case has been adjourned to May 17, 2011 for hearing. Justice Idris Mohammed of the Federal High Court, Lagos, has dismissed the application of a former governor of Edo State, Lucky Igbenedion, challenging the order of the court that approved the temporary seizure of his property by the Economic and Financial Crimes Commission for lack of merit. The former governor had, through his counsel, Ricky Tafa SAN, challenged the order of the court that granted the EFCC the right to attach his property situated in various parts of the country, including Abuja, Lagos, Benin, and London. In his ruling on Friday, April 8, Justice Idris Mohammed said the order of the court dated February 28, 2011 was not in error or irregular as it was within the powers and jurisdiction of the court to do so. He said the court order was to give effect to Section 28 of the EFCC Establishment Act 2004, which empowers the agency to temporarily attach the property of an accused person if it is suspected that the assets were acquired through proceeds of economic crimes, and also to prevent a suspect from disposing the assets when he is under investigation. He said the courts can make an interim order within jurisdiction and outside jurisdiction if it is sure that the assets belonged to an accused person. Again, he said the jurisdiction of the Federal High Court was the territorial land of Nigeria, as the Federal High Court is one, citing Section 19 of the Federal High Court Act and Section 250 of the Constitution of Nigeria. Justice Mohammed said it was a misconception that he made an order for forfeiture, explaining that the order he issued was an order of interim attachment and therefore dismissed the application for lack of merit. Rotimi Jacobs, counsel to EFCC, had on March 18, 2011 urged the court to dismiss Igbenedion's application, asking it to set aside the attachment